January 25th Judiciary Committee meeting. We will start off with requests for bill introductions. I know Nancy Strauss has a couple on behalf of the Judicial Council. Come on up, Nancy. I guess I should ask the committee first, but you're here, Nancy. Come on up.
Good afternoon. I'm Nancy Strauss. I'm here on behalf of the Judicial Council to request two bills. The first one is 22 RS 2651, and this bill would prohibit a court from denying a petition for expungement due to a petitioner's inability to pay outstanding cost, fees, fines, or restitution, and that is the inability is distinguished from unwillingness. The second one, 22 RS 2728, is the exact same policy, but applied in Chapter 38 for petitions for expungement of juvenile offenses.
Any questions, committee? Not see any. We'll get those introduced.
Thank you.
Yep, thank you. Anyone else with a request? Not seeing any. We will move on. We have two hearings today. We'll open the hearing on House Bill 2495 and have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2495 would prohibit the disclosure of personal information about a person's affiliation with an entity that's exempt from federal income taxation under 501c3 of the Federal Internal Revenue Code. So the bill would enact a new section of law. It would provide that a public agency shall not require an individual to provide personal information, require an entity that is exempt from federal income taxation to provide personal information, release or publicly disclose personal information, or request or require a current or prospective contractor or grant recipient to provide a list of entities to which that contractor or grantee has provided financial or non-financial support. Personal information would also be confidential and not subject to the Kansas Open Records Act. Reports or disclosures required by Article 41 of Chapter 5, which is primarily our election law statutes, or Article 2 of Chapter 46, which is our state government ethics statutes. Those two types of reports and disclosures, valid warrants issued for personal information, lawful requests for discovery of personal information, admission of personal information as evidence, and the National Securities Association would all be exempt from the requirements of this new section. A person alleging a violation of this section would be able to bring a civil action for injunctive relief and damages. Damages would not be less than $7,500 for each violation of the section. In addition, reasonable costs and attorney's fees would be able to be awarded. And then a person who knowingly violates this section would be guilty of a Class C non-person misdemeanor. Subsection E provides definitions for the terms that are used throughout the Act. Specifically, personal information would be any list, record, register, registry, roll, roster, or other compilation of data that identifies a person as a member, supporter, or volunteer, or a donor to any entity that's exempt from federal income taxation. And then a public agency would be the state or any political or taxing subdivision of the state, or any agency of the state. And then finally, subsection F names the act the Charitable Privacy Act. And I can take any questions.
Questions?
Yes, Mr. Chairman.
I see. God, no matter your background, I cannot see your hand. Representative Carmichael.
Thank you,
It
Mr.
needs to
Chairman.
bounce up and down or something.
It would be very convenient for the committee if they just did away with my raise your hand button. We could get through the work a lot quicker. I appreciate your patience. Ms. Scott, some folks expressed concern to me last week or over the weekend that perhaps somehow this statute might interfere with the ability of the Kansas Department of Revenue to do, among other things, issue certificates of sales tax exemption to some nonprofit organizations. Do we know, is there an exception for their data gathering activities?
Mr. Chairman, Representative Carmichael, the exceptions to this new section would start page 1, line 27, and there is not a specific exception for the Department of Revenue.
Thank you. That's what I feared.
Any additional questions for Natalie? Okay, thank you, Natalie. We will start with proponents, and first up is Stephen Green.
Thank you, committee. Good afternoon. Chairman Patton and members of the committee, my name is Steve Green, and I'm here to offer proponent testimony on House Bill 2495, known as the Charity Privacy Act, and I'm testifying on behalf of Philanthropy Roundtable. I want to talk a little bit about the Philanthropy Roundtable and then also why we believe House Bill 2495 is worth supporting, and then specifically what it does at a local level. So Philanthropy Roundtable was founded in 1991, and its mission is to foster excellence in philanthropy, protect philanthropic freedom, and help donors advance liberty, opportunity, and personal responsibility. Today, the Philanthropy Roundtable has about 600 members nationwide, including members here in our state of Kansas. House Bill 2495 really is about strengthening the vitality and breadth of a civil society in the state, in the nation, through making the ability for anonymous donations to charitable organizations. There are a lot of reasons why Kansans choose to keep their donations private, including, but not limited to, privacy concerns, religious convictions, and fear of harassment. There's in the testimony, there's a reference to survey of Americans. We would say that overall Americans support the idea of anonymous donations and protecting charitable donations as anonymous. This is based on in a lot of different world religions amongst a shared principle of private giving. For example, in the Gospel of Matthew, it makes mention of be careful not to practice your righteousness in front of others, or not to let the left know what the right hand is doing. Other religions have taught that sort of principle of anonymous giving, and so we feel like this is important because it allows people to express their First Amendment right of freedom of symbol, but also religious expression. The right to give and associate privately has been upheld several times by the Supreme Court, including in last summer's Americans for Prosperity Foundation case and in the 1958 NAACP versus Alabama case. In that 1958 the Supreme Court ruled that the state of Alabama could not force the NAACP to turn over its members and donors without first violating the First Amendment. Again, there's some examples about anonymous giving in the state of Kansas recently, including a donation that was made to Washburn University. But I just want to highlight that this is really about helping organizations that would be potentially otherwise at risk of litigation from violating privacy of their donors. The bill prohibits public agencies from disclosing or releasing personal information about membership, volunteers, and financial and non-financial donors of nonprofit organizations except as required by law. Every American, we believe, has a fundamental right to support the causes. We think that if a charitable organization is subject to having to disclose their donations, that could have a chilling effect on donations. We are aware, and we have been in discussion with the Kansas Secretary of State's office and the Kansas Attorney General about some language that they're going to make recommendations for that we support, and we appreciate their feedback and that opportunity. Mr. Barker, I believe, will address that language. Again, thank you very much for your time. We appreciate this opportunity to provide proponent testimony. And with that, Mr. Chair, I'll close for questions.
Very good. Representative Heiberger?
Thank you, Mr. Chair, and thanks for being here. Does this bill as drafted apply to 501c4 organizations?
It does. So it's all 501c organizations.
Pardon me for being snarky, but you did mention that it might be about the left not knowing what the right is doing.
Touche.
And another question, and this is a little more serious. It comes from some people in the advocates for people in adult care homes. I wasn't until yesterday, so I suspect you're not familiar with the Patient Portability and Affordable Care Act, PPACA. It's a federal law that requires disclosure of certain information about nonprofit skilled nursing facilities to the state and requires the state to publish those. I mean, do you think?
I am not personally, but it's definitely something that we'll consider, and we'll get back to the committee.
Be open to a carve out for that?
It's definitely something we would consider or can consider.
Okay.
Yes, sir.
Representative Carmichael.
Thank you, Mr. Chairman. I have a couple of questions. First, I didn't realize that the membership lists of, say, 501c3s, for example, are public records, or that I would have any way to get a hold of those. So today, without this law, if I want to find out the membership of, say, Equality Kansas, a 501c3 organization, how would I go about getting their membership list today? I might want to even send campaign solicitations to them.
Thank you, Mr. Chair. What I would say is it's not to say that information is out there in the public and readily available. What this is doing or attempting to do is to protect specifically the litigation, and then also the requirement to release documentations through litigation. In the case for the Americans for Prosperity, the most recent example, there was a lot of resources financially and personal that at least I would imagine that they would have to have expended to go through the judicial system to try this case. And so while that information, to your point, and it's a fair point, isn't maybe readily available as a C3, it would prevent, by codifying it or memorializing it in statute, from it being required to be released through sort of litigation, if that makes sense.
Yeah, so even in the context of a lawsuit where there were perhaps allegations that a charitable organization that a political organization was masquerading as a charity, you want a law that would prevent the litigants from even finding out who's really providing the money, say for a Koch family endowment at the University of Kansas through a 501c4? Is that something you want to put a lid on so we don't find out who's trying to influence the faculty, say, at the University of Kansas in terms of who gets to be a professor and who doesn't?
Mr. Chair, that I can assure the committee that is not necessarily the intent. It is the intent overall is that we want the ability, and we want to advocate for the ability for an individual to make a donation. This is really thinking of the small community foundations or small local nonprofits that do receive, for example, the Topeka Boys and Girls Club here in town receives donations, and people give it anonymously to that organization. And that's really the intent, is that those individuals who give can continue to give and do so in an anonymous nature, and not feel the need to feel with, what's the word I'm looking for, not compelled to give because they're worried that their personal information could be made public otherwise.
And then finally, Mr. Chairman, I take it then, no matter what your intent is, you do understand that the plain black letter law of what you propose is not confined to small nonprofits. In fact, it would apply to national 501c4s who are spending, I think, perhaps as much as 60 or 80% of their membership dues to influence elections. Is that what you really want to accomplish here?
We want to ensure that the state of Kansas has a environment that is amenable to philanthropy. That's the important thing that we want to highlight in what we're proposing.
Yeah. Thank you very much. Thank you, Mr. Chairman.
Representative Samsel.
Thank you, Mr. Chairman. Thank you for being here today. My question is on, it's page 1, down to lines 33, 34, and it talks about a lawful request for discovery. What are we Is that like I'm a civil litigator by background, is that a request for production of documents, subpoenas? It gives me a little bit of heartburn when it looks like it's imposing in subsection A and B, there's some additional requirements when we're getting into litigation, if you could help me understand that.
Sure. Mr. Chair, thank you, Representative, for the question. I am not an attorney by trade. If it is okay with you, I would feel more comfortable to round with those that are attorneys to answer that question and get back with you at another time. I'm sorry, I do not want to offer any legal advice or interpretation on something that I run the risk of giving a bad answer to.
Sure, I appreciate that. And if I may have one follow-up, Mr. Chairman?
Sure.
And it may be another question for another attorney, but I was curious, down on page 2, lines 9, 10, and 11, when it talks about injunctive relief or damages, I'm curious as to where the damages award of not less than $7,500 for each violation. I don't see that each violation is defined in this bill, so I'm curious as to how that would be interpreted and the potential that a court would be mandated to award perhaps multiple instances of $7,500 or more. So those would be my two questions from a litigation background, I guess.
Okay. Mr. Chair, thank you. If it's okay, I'll definitely connect with you to, thank you.
Yes, thank you. Thank you, Mr. Chair.
Any other non-legal questions? Okay, perfect. Thank you.
Thank you.
Next, we have Carrie Gooch.
Good afternoon, Mr. Chairman. Good afternoon, committee. Thank you guys for allowing me to be here. I am here on behalf of the Kansas Black Leadership Council, KBLC, as some of you might know. The Kansas Black Leadership Council was founded about 10 years ago with a mission to assemble organizations in the state of Kansas that share a concern and common goal of building a stronger, healthier, and better informed African-American community. Some of you might know the Kansas Black Leadership Council as the organization that puts on Black Legislative Day at the Capitol every year. And with that being said, I'll put in a quick plug that we're having Black Legislative Day at the Capitol this year, February 9th in person. We're really excited to be back in the Capitol, and we hope to have the opportunity to talk to many of you here that day. A little bit more about the Kansas Black Leadership Council. Again, we are an organization made up of organizations. We cover lots of different organizations all across the state, whether it be ministerial leagues, fraternity organizations, the NAACP, lots of other African-American professional organizations as well. Most of these organizations fall under this 501c apparatus structure. I won't go over a lot of the things that my colleague just talked about on this bill. I know you guys have read it and answered a lot of questions about this already, but one of our organizations, the NAACP, who's also submitted testimony, talked a little about the NAACP versus Alabama case and kind of how we actually got involved with this situation to begin with. Again, we stand here in support of House Bill 2495 because we believe it ensures that organizations can continue to keep their membership private. Representing an organization that represents African Americans, we have lots of organizations that at some time over the past have been seen as controversial in nature. And we know it's important for our organizations and the people that make up our organizations sometimes to be able to remain anonymous, and as well as when it comes to their charitable giving as well. We believe this bill keeps agencies from having to disclose and releasing our organization's financial information. And we also believe that this bill adds in another layer of protection for organizations like ours. Again, I will keep this short and be open to questions, but again, we ask you all to support House Bill 2495. And thank you, Mr. Chairman.
Thank you. Any questions, committee? Do not see any.
Yep.
Oh, sorry, Boog. Representative Heiberger. That was Susan's fault. She called you Boog. Not that Susan, other Susan. Yeah.
Thank you for being here, Mr. Gooch. Does the organization that you represent, is it a 501c3 or another?
It is a 501c3, yes, sir.
And would you have any concerns about limiting this bill to 501c3s? Or excluding 501c4s?
Excluding 501c4s. Our organization covers organizations that are a part of 501c4s. So again, we believe that it's important for them to have protection as well. We'd be happy to kind of talk about that a little bit more, but our stance right now is we prefer all 501c organizations to be a part of this legislation.
Any other questions? Very good. Thank you.
Thank you, Mr. Chairman.
Committee, in your, I guess not your file, on your computer, you have written proponent testimony from the Kansas Policy Institute, Kansas Family Voice, and the NAACP. Anyone else here as a proponent? Okay, we will move on to neutral, and first we have Tom Witt.
Good afternoon, Mr. Chairman, members of the committee. Tom Witt with Equality Kansas. We advocate for the LGBT community here in Kansas. We're neutral on this bill. I'd like to be a proponent, but there's some holes in it. So first of all, our organization has three pieces. We have a 501c4, which is our primary membership organization. That's what I work for. We have a 501c3 educational foundation that has its own board. And then we have a political action committee, which is affiliated with our 501c4. And that political action committee files regular reports with the Kansas Governmental Ethics Commission, where we do disclose our contributors and our expenditures. As a membership organization that advocates for a class of people that has been regularly persecuted in this state, I would say that this is necessary. We don't want our membership or contributor lists for our C4 and C3 ever exposed. People on that list, on those lists, could be subject to retaliation, could be subject to harassment and discrimination. I will note that at least one member of this committee is a member of our 501c4. Okay? So this is important for us. But one of the big holes that we see in this is it does not cover, well, actually two holes. It does not cover not-for-profits that are registered through the Secretary of State rather than having applied for a determination letter through the Internal Revenue Service. And it does not cover organizations that have formed and have a determination application pending before the IRS. And I will say, having had to have gone through this process, that sometimes getting that determination letter, if you have punctuation out of place, it goes from 8 months to a couple of years to get the determination letter from the Internal Revenue Service. So in that time between formation and actual ruling from the feds, that needs, I believe, should you pass this bill, I think that needs to be addressed. That's our position. We'd like to see this fixed up a little bit. We'd be happy to work with proponents. One proponent did mention that they didn't feel like the penalties in the bill were quite strong enough. We'd be happy to talk about that with the proponents. So if there's any questions, I'd be happy to take them.
And Representative Carmichael.
Thank you, Mr. Chairman. I should make a disclosure of interest. As far as I know, my wife and I are still family members of Equality Kansas 501c3. If we're not, Mr. Witt, I've got my checkbook in my office. Thank you.
Representative Carmichael, you are a member of our 501c4, not the C3. And we would be happy to take a check in any amount you care to write.
I'll be in my office, Mr. Witt.
I know where that is.
Any other questions? Good, thank you.
Thank you very much.
Clay, are you just written, or do you want to talk to us? Okay, come on up. Clay Barker, on behalf of the Kansas Secretary of State's office.
Mr. Chairman, thank you for giving us the opportunity to testify. I'm Clay Barker, the General Counsel for the Kansas Secretary of State. And a quick note, I'd like to thank the chair for his forbearance. When I came in this morning, I didn't realize I'd be testifying today, and the Attorney General sent us a heads up to read this bill. It might impact our office, so we threw together some testimony, and I apologize for not being dressed appropriately for this, this committee hearing. Briefly, we are neutral on this bill because we don't believe the intent would touch anything our office does. It seems to be focused on protecting the donors, members, and volunteers of organizations that are granted tax-exempt status under IRS Section 501c, and that's 501c1 to 29. And if you were wondering, political organizations are tax-exempt under 527, so PACs, parties, candidates, they're not touched by this bill. The reason we're testifying is we believe it's possible to interpret the bill to create a conflict of law between the prohibition that's in this bill and our office's statutory duty to request personal information of officers, directors, resident agents, and on occasion, major owners of corporate entities. So we can put that out in public, because that's how an organization gets its corporate protection, is because that information is made public so people know who's behind a corporation. It would also affect other filings in our office that include union filings, which come under 501c5. I mistakenly put C6 in our testimony, and certain cemeteries, which come under 501c13. And I believe the Attorney General has similar concerns, a little different in their written testimony. And we stand ready to work with the reviser and the proponents. We've talked to them already about crafting a clarification or exemption to address these needs. And Mr. Chair, I stand ready to answer any questions.
Any questions? Not seeing any. Thank you.
All right, thank you, Mr. Chair.
Committee, you also have written neutral testimony from the Attorney General's office. Anyone else as a neutral conferee? Any opponents? Okay, we'll close the hearing on this one, and I encourage you all to get together and work. Oh, yes, Representative Heiberger.
Ask a revisor question before we close
Sure.
the hearing. Natalie, is my memory bad, or is it unusual to have a minimum fee rather than a maximum fee in the statute? I mean, a penalty?
Mr. Chairman, Representative Heiberger, I'm not sure if I would say that it's unusual. I don't think it's super unusual. I would have to do a search of the statute base to determine how often that happens, but I know certainly that I draft it both ways with some regularity.
No search will be necessary. Thank you.
Okay, so we're going to close the hearing, get together, let me know if we're making progress, and we'll move forward. Next, open the hearing on House Bill 2527. And again, we'll have Natalie tell us what it's about.
Thank you, Mr. Chairman. House Bill 2527 removes the authority for law enforcement officers to deliver a child in need of care to a court services officer, and it also prohibits supervision of persons found not guilty by reason of mental disease or defect by court services officers. So Section 1 amends KSA 223428. Current law in that statute allows the court to place patients who are found not guilty of a crime by reason of mental disease or defect under the temporary supervision of district court, probation and parole services, a community treatment facility, or any appropriate private agency. This bill would amend that section to provide that the patient would not be supervised by court services officers. And then Section 2 amends KSA 382232. Current law there provides that when law enforcement is unable to deliver a child in need of care to the custody of a parent or other custodian of the child, law enforcement would be able to deliver that child to a shelter facility, a court services officer, a juvenile intake and assessment worker, a licensed attendant care center, a juvenile crisis intervention center in certain circumstances, or to another person. This bill would remove the option to deliver that child to a court services officer. And I can take any questions.
Representative Carmichael.
Thank you, Mr. Chairman. Ms. Scott, I may have not heard what you said accurately, but my recollection is that this is a fairly recent law. Didn't we pass this comparatively recently?
Representative Carmichael, which part are you talking about? The juvenile?
Yeah, the delivery of juveniles to the custody of a CSO as opposed to a juvenile detention facility. And I may be completely wrong on that. I'm just trying to recall.
So in Senate Bill 367 is when you would have added that juvenile intake and assessment worker, because we kind of changed the term that those people are called in Senate Bill 367. And then later in Senate Bill, I believe it was 179, when you created juvenile crisis intervention centers, that section was amended again to include those folks as a place where law enforcement can deliver a child. But as long as I've been working in this area of law, the court services officer option has always been there in the statute. I'd have to go back to see when that was added.
It's not necessary. I was not thinking clearly, but when did we add those additional parties who could receive a juvenile? The two bills you just referenced.
So the juvenile intake and assessment worker, which that one could have been called someone else. We just changed the name of those folks. That was in Senate Bill 367. So that would have been in 2016. I can do a little research on that one. And then the juvenile crisis intervention centers, that would have been, That's Senate Bill 179. I think that was maybe in 2017, 2018, somewhere in that range, but I can get you that exact year for sure.
No need for that. That's close enough. Thank you, Mr. Chair.
Any other questions for Natalie? Okay, thank you. For proponents, we have Amy Raymond here today on behalf of OJA.
Good afternoon. Chairman Patton, members of the committee, thank you for having me today. My name is Amy Raymond. I am the Chief of Trial Court Services for the Office of Judicial Administration. Much of my responsibilities cover things that go on in the trial courts. That's how I like to broadly describe it, including administrative oversight of our court service officers. In November of 2018, the Supreme Court commissioned the National Center for State Courts to do a workload study on the work that our court service officers do. And following that study, they formed a work group to look at all of the CSO tasks, review statutory provisions that were related to that work, look at organically arising local practices surrounding that work, and make recommendations to the court. The work group submitted its report in fall of 2019, and the two recommendations that are in the bill before you today are a result of that work group's actions. So the first one that Natalie discussed, removing court service officers as a supervision option for those who are found not guilty by reason of mental disease or defect. The work group concluded after its analysis that CSOs really don't have, currently, they do not have the specialized experience or mental health training to supervise those individuals. So that's the reason for that recommendation. The second recommendation related to law enforcement placing a child in the custody of a CSO. CSO offices are really not situated to take custody of a child. They would be in an administrative setting, and that's just not appropriate for that vulnerable population. So we're recommending that CSOs be removed as a placement option for those children as well. So I would be happy to stand for any questions that you may have.
Representative Carmichael.
Thank you, Mr. Chairman. This is going to be another instance where I can't remember what we did a year or two ago, but I know we looked at some similar legislation regarding the scope of CSO's authority or work or whatever. And my recollection was that there were some districts where CSOs were being used in a fashion very different than they were in other judicial districts. So the subject matter of this bill, will it impact any present practices in any judicial district? Or is this just something to make sure, I guess, it doesn't happen someday in the future?
Representative Carmichael, to my knowledge, this work is not being done in any district. If any committee member knows differently, please let me know and I will run that down. But this should not impact any current practice, because the current practice is a CSO involved in supervision with the families, working with the families, connecting them to resources and such, and this involves placement of a child in the custody of a CSO.
Are court services officers subject to the jurisdiction of the court and perhaps therefore subject to court rule if the court chose to adopt such a rule?
Yes, sir.
So why do we need legislation if it's not happening, and if the court has the authority to prohibit it if the justices thought that that was appropriate?
To my understanding of the law, sir, we cannot create a court rule that circumvents statute. So we need to remove it from statute.
Okay, I misunderstood you. I thought you had said yes, that CSOs were under the jurisdiction of the court and it was amenable to a court rule. Is there a statute, presently existing statute to the contrary, which would prevent the court from adopting such a court rule?
I don't know of one, and I apologize that I misunderstood your original question. They are subject to the jurisdiction of the court, but allowing this in statute would still allow a court to place the child in the custody of a CSO. And I don't believe that the Supreme Court could create a rule that circumvents a statute.
Well, with respect, I think if there is a statute that would be contrary to a court rule, that the court would not have the ability, at least in most instances, to pass a court rule in contravention of state law. But I thought you told me there wasn't a state law that specifically authorizes CSOs to take charge of juveniles or people who've been adjudicated as mentally ill or otherwise. Did I misunderstand?
I don't know that you misunderstood. Perhaps I misspoke and I was not clear. The current statute allows for the court to place a child in the custody of a CSO, or in the other instance, allows a CSO to be ordered to supervise an individual who has been found not guilty by reason of mental disease or defect. We're asking that CSOs be excluded from that work, that a statute be amended to exclude them from that work.
I apologize. I must have misunderstood. I'm only hearing out of one speaker in my ear right now. But you're saying that there is a specific state statute that says a court may place juveniles or folks in the mental circumstance we've described in the custody of a CSO, and share with me what statute that is, just so I can take a more precise look.
Give me one moment. I will look that up. The statute that allows supervision for someone found not guilty by reason of mental disease or defect is 22-3428. And the statute that allows placement of a child in who may be a child in need of care in the custody of a CSO is 38-2232.
Thank you for educating me. I do appreciate your help. Thank you, Mr. Chairman.
I apologize if I caused any of that confusion.
Representative Wheeler.
Thank you, Mr. Chair. I wasn't confused at all. I thought you were quite clear, but I do find interesting. Did you say behave, Mr. Speaker?
Oh, but do I need to?
I'm interested in that the present statute that authorizes a court to place a child in the custody of, as opposed to temporary placement for placement. Custody means that CSO's got to take that child home.
Theoretically, arguably, yes. Or somewhere with them, like make sure that that child stays with them. Yes, which is our concern.
Surprised we passed that. Okay, thank you very much.
And as Natalie pointed out, I don't know how long that's been in there. But this was an opportunity for the work group to look at that work. We looked at everything, and so.
Thank you very much.
Any other questions for Amy? Okay, thank you.
Thank you.
Any other proponents? See any neutral? We have written neutral testimony from the Johnson County Sheriff's Office that has been emailed out. Any other neutral testimony? Any opponents? Okay, hearing on House Bill 2527 is closed. Those are the only two bills we're hearing today. Committee, we have two bills up for tomorrow. Also, if we have time tomorrow, which we would have had time today, but I didn't get you a list, so we're not going to work bills today. So tomorrow, be potentially ready to work 2299, 2473, and 2474. And then I also want you guys to look at Senate Bill 102. We heard Senate Bill 102 last year, March 16th. It deals with sexually violent predator program. It had quite the fiscal note, and so we heard it. It was kind of late in session, and we didn't work it. We may work that this year. So I want you to look at it. If we need to have another hearing or invite back the Attorney General's office and Natalie, I don't know for sure what we want to do there, but I want you to look at it and let me know. Again, if you need more information before we work it, I certainly want to provide that. So get me that feedback. It's not up to work tomorrow or anytime soon, but likely at some point in time. That is all I have for today. Reminder, we are not meeting Thursday or Friday, so tomorrow's the last day for us. And we'll have a long weekend and come back. We're finally getting some bills in committee, so next week should be a little bit more busy. With that, have a good evening. We'll see you all tomorrow. We are adjourned.